All right. In the interest of trying to get started on time today, I will get us off, hopefully on the right track. My name is Taylor Kohler. I am a staff attorney here at the Center for Human Rights and Constitutional Law, and I work on our policy and our programs. Today, we are going to have a webinar on leveraging UN mechanisms to protect immigrant clients, and it's on new tools for American attorneys and advocates. And before we get started, just a few brief announcements. If you have any questions, please feel free to put those in the Q&A. Our chat is disabled just to keep things clean so we don't miss any questions. So again, all your questions into the Q&A. My colleague Karen is here to support as well, and she'll be answering some of the more administrative type questions that get dropped into the Q&A. So she'll try to monitor that as we go. And then when we get to the end, I will try to answer any substantive questions that are in the Q&A. Other things that are important is this is a CLE credit in California. And when you registered, you would have hopefully noted that you were, licensed in California. We will make sure to send out your CLE certificate. I will be doing that via email, hopefully tomorrow. For all other attorneys, we also send out a certificate of participation, so you can use that in other states as well. This PowerPoint will be sent out after, and we are going to send out kind of like a handout to help everyone with this process. That's a little, hopefully, a tool to use, as well as any links and resources. The PowerPoint does have links as well, so you'll be able to use those when you receive that. And there will, yeah, so I think that's everything. Hopefully I didn't forget anything. I'm sure if I did, you all will put it in the Q&A and we will get to that. But I guess we can get started. So just a brief overview of our agenda for today and kind of where we're headed. We're going to start out just doing an overview of sources of international law. And I kind of want to preface all of this by saying I know for a lot of American attorneys, we don't really turn to international law very often. There's a whole host of reasons for this, right? I mean, it's not particularly, um, welcomed in US courts, and it's often downplayed politically. But we are in this moment where international law and some of the UN mechanisms can be a tool for us, and it seems more important than ever. And so, really, my hope today is that I can give you a little bit of knowledge on international law to ground you as you start to think about these topics if you haven't done so before. Um, and then we're going to turn to, a discussion of what is an enforced or involuntary disappearance under international law? What does that mean? And then we will move into kind of the very practical components, which is what are those UN mechanisms for engagement in order to support clients or individuals that you're supporting. And we're going to look at both the Committee on Enforced Disappearances and the UN Working Group on Enforced or Involuntary Disappearances. And then finally, we will go through how to report a disappearance. And then we'll touch on after that, we can take all the questions and touch on some other things that can be useful tools as well. So I guess we can move on from here. So the first thing we're going to talk about is what are the sources of international law? And I'm not going to get into the weeds on this. I don't think it's, the most helpful, but what we'll focus on is this distinction between hard law and soft law that occurs in international law. And hard law is kind of the highest priority. These are binding laws, and the most important of these is treaties. And other names for treaties, we have treaties, conventions, protocols, and charters. And all of those are the principal means by which international law is made. And these create both legal rights and duties and obligations. And entering into any of these agreements is an attribute of state sovereignty, right? A country doesn't lose its state sovereignty, they're choosing to do it because of their sovereignty. And then just something else to flag when you're thinking about treaties is that all treaties also have something called RUDs, and these are reservations, understandings, and declarations. And they're provisions of a treaty that one or more parties refuse to accept. Might be they refuse to accept it. It could also be the country says, this is the way I interpret this provision, or I interpret this in line with certain domestic law. So just something to be aware of if you're looking at treaties, which I hope that all of you are going to be doing more of if you're not already doing so, but that you want to check into the reservations, understandings, and declarations for the US for different provisions. And also important to know is that certain of these are not allowed if the treaty actually prohibits them, or if those reservations, those RUDs, are incompatible with the object and purpose of the treaty. But that's just something to be aware of with treaties generally. Then we also have another hard law source, and that is called customary international law. And this is law which evolves from state practice. And in this case, we have divergent practices of various states that are converging, and they have to achieve a level of uniformity, consistency, and regularity that generates a sense of legal obligation. So this is generally understood through state practice and state writings. And you want to see state practice that is virtually uniform, extensive, and representative. An example of this is like torture, for example. Even when states are torturing an individual, they go to great lengths to say that it's not torture, right? They know that there's a legal obligation there. And so even though many of us advocates are like, okay, we know that, torture or inhuman, degrading treatment is happening, the states are trying to say that it's not that, right? Because there is, and that's one of the strongest areas of customary international laws around torture. And so that's an example of what that might look like. And so you're going to look for, when you're looking for customary international law, density and consistency of the norm. And the rule is essentially based on implicit state consent. And customary international law is considered hard law. It is considered binding. It is considered right up there with treaties. It isn't a, oh, maybe sort of situation. It's no, this is a legal obligation. So that is something we want to know as we move forward. And then finally, we have, after those two areas of hard law, we have something called soft law. And soft law is non-binding international instruments that contain norms, principles, and they articulate these ideas. But they are neither strictly binding, but they're not completely void of any legal significance. Soft law is used in international jurisprudence by UN bodies to shape interpretation of the legally binding provisions. And those soft law kind of components of international law comes out in opinions and jurisprudence. So it's somewhere in the middle. It's not the binding part like the treaty provision itself, but it's used to interpret and understand often the individual provisions. And some of those instruments of soft law are things like coming out of the UN General Assembly, for example, would be resolutions, declarations, guidelines, recommendations. All those things coming out of the General Assembly are soft law. You also have the UN Human Rights Treaty bodies. Those are the bodies that oversee human rights treaties. So the Convention Against Torture has a UN body that monitors implementation of that. Each of the treaties have a human rights treaty body. And then those bodies produce reports, observations, general comments, decisions, communications, kind of everything that they generate, that's all soft law as well. And then we have UN special procedures. And the special procedures, those don't come out of treaties. Those are kind of created by the Human Rights Council. Um, and they include things like the special rapporteurs, the working groups, and also the Universal Periodic Review, the UPR process. So those are all your special procedures. And again, everything that those bodies produce is soft law. And then you also have jurisprudence of international courts and commissions. Those decisions are binding on the state parties, but what is said in those decisions isn't binding on other states, but it does generate soft law. And then finally, we have like normative resolutions of international organizations. So you might have, global meetings and they create compacts. All of those that kind of create all these norms, all of those are soft law. So all of those things exist and they're not law themselves, but when you violate them, they do give rise to political consequences. And that might be a political consequence within the country, and it could also be a political consequence on a diplomatic level. And something that's really important to understand about soft law is that any of these norms can what's called harden into customary international law as a consequence of state practice. So while these bodies and the special rapporteurs are writing and interpreting and trying to understand treaty provisions and customary international law, all of this starts to shape state practice. And then over time, it can actually become binding hard law, becomes something that a state has to legally follow, even if they never signed a treaty. They don't have to sign the treaty on it, but because the world started following this norm, it's now considered legally binding. So that is hopefully our quick grounding on these areas, these sources of international law, and these will help us understand as we move forward. So the question is, why does all of that matter? And that brings us to understanding enforced disappearances. And I have here the definition of enforced disappearance. This definition is from the International Convention for the Protection of All Persons from Enforced Disappearance. This is the treaty definition. There's also a declaration that we're going to talk about. I didn't put the language from the declaration. It's almost exactly identical, just slightly different, but very close. And so now we're going to learn about what is an enforced disappearance. And there are three elements really of enforced disappearance with kind of a fourth one that is the result. So an enforced disappearance is a deprivation of liberty against the will of the person. It requires the involvement of government officials, at least by acquiescence. So, it doesn't have to necessarily be the government. It could be a paramilitary group. In the US, right now, what we're seeing, it is the government officials themselves. And then that third element is a refusal to disclose the fate and whereabouts of the disappeared person. And the consequence of that is you remove that disappeared person from the protection of the law. So those are the elements, and we'll kind of talk through those. So a deprivation of liberty is initiated either by an illegal detention or an initially illegal arrest or detention. The deprivation of liberty here does not have to be limited to cases of illegitimate deprivations of liberty. So even if the arrest started out in a legal format, right, it is authorized by our law, you can still end up in this enforced disappearance area. And it covers all forms of deprivation of liberty in any place, and not only in like official detention centers by authorities. It could be that, someone's being detained in an office building or they're being detained in a basement. all of those places are going to be covered in all of the circumstances. It's very broad, it's very all-encompassing. And I think, especially for American attorneys, right, we're like, okay, well, what exactly does that mean? How narrow is that? And I would encourage everyone to think very broadly about this, not to box themselves in, because that's how the UN interprets it. Then we have the involvement of government officials. So the act that deprivation of liberty has to be perpetrated by state actors or by private individuals or organized groups acting on behalf of, or with the support, direct or indirect, consent or acquiescence of the government. Much of what's happening in the US is the government itself, but something to be thinking about is as we see more of these third country renditions or removals, as the government would call them, to third countries, you may start to see more non-state actors involved, something that maybe we haven't dealt with as commonly, but that's possible. And so if we have this happening where, it's another organized group, or it's a paramilitary group, those are all covered as well. But what you're looking for is some sort of link to the state. And then the most important component here is this concealment of fate or whereabouts. And this is the element that really distinguishes enforced disappearance from other offenses, such as like arbitrary detention. Within enforced disappearances, there's this whole host of human rights violations, but the one that really sets it apart is this idea that someone is missing, right? This family member, this human, no one knows where they are. And that is really kind of like, I'd say, the gut of this violation. Really important to understand here is there's actually no duration element for how long someone's fate or whereabouts has to be unknown. So short-term disappearances are still disappearances. If a family member and, counsel don't know where someone is for 2 hours, 3 hours, 8 hours, as often is the case for the ICE detainee tracker, all of that is a disappearance. Any amount of time that someone is unknown, that they've been taken, that they're being deprived of liberty. So I think that's a really important component here is it doesn't have to be for a long time, right? So, and then finally, we have this removal from protection of the law. So essentially, because this person is deprived of liberty, they're left defenseless and they are deprived of protection from the law. And there isn't an intent element here. There doesn't have to be an intention to remove the person from protection of the law. There is an exception if you were looking at prosecuting this as a crime under the Rome Statute, which is the International Criminal Court, then there is an intent element. But for purposes of assisting our clients in reaching out to the working group and the committee, as we're discussing, there isn't an intention element. And something to point out here, as I was saying earlier, is there are all these violations that come with an enforced disappearance. And so this is just a list. I'm not going to go through them, but something to note is that the UN, when it talks about enforced disappearances, is recognizing all these human rights violations. And so when you're thinking about reporting this and sharing information up to the United Nations, as I'm hopefully going to give you tools to do, you know, it's good to recognize these other violations that might be happening and to point out what those are and make those explicit for the UN body. So this is just a list. It's not all encompassing, but these are just ones that hopefully you'll be able to refer back to and be like, yes, I want to make sure to include this. So now we're going to look at what is the international law around enforced disappearances. And I know we discussed those hard law, soft laws. Now we're going to point those out. For hard law, we have the International Convention for the Protection of All Persons from Enforced Disappearance. That is a treaty dedicated just to enforced disappearances. There's also the Rome Statute of the International Criminal Court that criminalizes enforced disappearances. And then we also have the Inter-American Convention on Forced Disappearances of Persons. We're going to focus on the International Convention for the Protection of All Persons on the treaty side here. And then for the soft law, we have the Declaration on the Protection of All Persons from Enforced Disappearance. This is a declaration, so it's not a treaty. But even though it's in the soft law, some provisions of that declaration have attained the status of customary international law, which would actually make some of those provisions hard law. But as a whole, the declaration itself is soft law. So we will kind of jump into, to start, the International Convention for the Persons. We are going to call it the convention. I'm not saying this every time. So the convention was adopted by the UN General Assembly in 2006, and it entered into force in 2010. And the US has neither signed nor ratified this convention. And so this convention cannot be enforced as to the United States. But it's really important to remember that just because it can't be enforced as to the United States, it doesn't mean we shouldn't think about it. Because as we have more of these third country renditions and we have immigrants being sent to other countries, there's a good chance that some of those countries may have signed this. And so even though in our head we're like, oh, well, we don't have to worry about that because the US hasn't signed that, it's good practice to be thinking about, okay, but where are they being sent? Where might they be being sent? And have those countries, ratified this convention. And just to point out that the preamble for this convention recognizes a whole bunch of other international conventions, treaties. So the ICCPR, the ICESCR, and they mention the history of the declaration. So there's this whole set of international law that is getting pulled into this. And so when you might have violations happening in other treaties as well. I'm just going to point out some of the main articles to know here. We have Article 1 in the treaty that says no one will be subjected to enforced disappearance. And it says there's no exceptional circumstances whatsoever. And this is particularly important because this administration is really focused on, right, there's invasions, this is, all sorts of public emergency exceptions to try to do all the things that it's doing. But international law doesn't consider that you can say, oh no, I'm in a war, or oh no, there's a public emergency. I have to do this thing. That isn't accepted. And actually, there's many provisions in international human rights law where there is such an exception. So when it's explicitly written out like this, it's very intentional that it's intentionally done, I guess, because there's other human rights provisions that exist where this is not the case. But here, those exceptional circumstances don't exist, even if the administration would like to think that they do. Also, Article 5 points out that the widespread or systemic practice of enforced disappearance is a crime against humanity. And that crime against humanity is what we talked about, I briefly touched on in the Rome Statute. And it also shows up in other places of human rights law. But this is language that we can be using as advocates, as attorneys, when we're talking about this thing, because this practice is becoming widespread and systematic. And now we'll move on to the Declaration on the Protection of All Persons from Enforced Disappearances. We'll call it the Declaration. This was also adopted by the UN General Assembly in 1992. And this is soft law, which means it applies to all states. There's no signature or ratification required. So this does apply to the United States. And just like the convention, the preamble recognizes other treaty laws, recognizing that violations of enforced disappearances brings in all these other human rights violations as well. Here we have Article 1 talking about enforced disappearance as an offense to human dignity. It's this grave and flagrant violation of human rights. And that it puts the disappeared person outside the protection of the law and is a violation of international law. And then Article 2 says that no state will allow, basically, or permit enforced disappearances, and that they have to take all steps to prevent and eradicate it. So those are kind of the important ones. I would encourage everyone to actually take a moment to go read through both the convention and the declaration. They're not that long. I know we are all incredibly busy, but I think actually taking the time to consume some of that information grounds us in, like, what are we talking about? And then finally, customary international law. And I know we talked about that soft law can harden and become customary international law. And that is actually kind of the case with the Declaration. Much of the Declaration is understood to codify and consolidate into customary international law, and so that it becomes legally binding. And the prohibition of enforced disappearance has attained status as what's known as a jus cogens norm. And that's a principle of international law that cannot be set aside. There's no circumstances that would allow for that. And that matches what's in the treaty, in the convention that we talked about. There's a case mentioned from the Inter-American Court on Human Rights that's cited there that expresses this customary international law concept. And other special rapporteurs and bodies have spoken about it as such. So it's pretty well understood within the UN system, within regional systems, that this is customary international law. So what this means is, even though the United States has not signed the treaty, they are still legally bound to this concept through the Declaration, because much of the most important parts of the Declaration have become customary international law. I hope that is mostly an understandable idea. Okay, so now we're going to talk about the human rights mechanisms that have been created to address disappearances. Essentially, how does the United Nations deal with these situations, and how can we as attorneys and advocates engage with them? So we have two mechanisms. The first is the Working Group on Enforced or Involuntary Disappearances. This is a special procedure which is established by a resolution of the Commission on Human Rights. This is basically the pre-Human Rights Council, so it's been around for a while. And it's composed of 5 independent experts appointed by the Human Rights Council. And then we also have the Committee on Enforced Disappearances. This is the treaty body created by the convention, and it's composed of 10 independent experts nominated by states parties. We're going to focus our conversation on the working group primarily because that is where I think many of us will start to engage first, because that's where you go for disappearances in the United States. But just to note for everyone that the working group will help direct you. So let's say an immigrant has been sent, to a third country, and that third country is in fact a signatory and has ratified the convention. The working group can help tell you that and be like, okay, here's how we're going to get information over to the committee. So you can use your starting point to be the working group and not the committee. The working group will help you communicate with the committee where you need to. But we'll talk briefly about both, just so that we know both, but I'm going to focus primarily after we move on the working group. So the Committee on Enforced Disappearances can intervene, like I said, only in regard to states that have ratified the convention, the states parties. and they carry out their monitoring mandate on the basis of the convention, and so they can only deal with complaints against state parties. So they can't hear a complaint against the United States. And they perform their mandate, their job, through a number of different procedures, which are listed below. On their website, you can actually look up each of those and understand what exactly they mean. But we will discuss the ones that are most practical and useful for us. Um, Urgent actions is when the committee can request a state party to take immediate measures to locate a disappeared person. Where necessary, the committee can also request the state party to adopt interim measures of protection to protect the disappeared person, their family or relatives, and also to protect pieces of evidence that may be of relevance in a legal case. And they can also send individual communications. So an individual can submit a complaint to the committee, and then they consider whether the state party is likely to violate their rights. And they create a document that's called views, and they ask the state party to basically repair or prevent the damage and to avoid similar violations. Um, and that also has kind of the interim protection things. And of course, it's important to note that the UN doesn't have a police force. They cannot go make the state do these things, right? We all know that. We know that when the UN talks to the United States, particularly right now, it isn't going to do much, right? But some states are more responsive to the United Nations. And I know that's like really hard for us because we don't live in a country where that is true historically. But it is true that this can work and create pressure on other states. So I want us to like reframe. I think it's helpful to reframe our thinking as American attorneys where we don't feel like that's the case. That might be the case, especially in other countries that for diplomatic reasons, they don't want that pressure. So just remember that some of these things, even though you're like, oh, that isn't enforceable, the diplomacy can be more important for other countries than it is sometimes for the United States. Now we'll move to the working group. So the working group is competent with regard to all member states of the UN, so it can hear complaints regarding the US. And it carries out its monitoring mandate on the basis of the declaration, and it provides guidance to all states. And just like the committee, it has a bunch of procedures that it does, and we'll talk about the most important ones. So under its humanitarian mandate, it has urgent procedures. And this is where we're going to focus our conversation along with the next slide. So the working group receives, examines, and transmits to governments reports of enforced disappearances submitted by relatives of disappeared individuals or by human rights organizations, which would be us, lawyers, NGOs, all the civil society organizations who are acting on their behalf to assist in determining the fate and whereabouts of family members who are disappeared. And then these urgent procedures occur if the case has occurred within the 3 months preceding receipt of the report. So they're pretty speedy. Or they also allow it if it's not more than 1 year before the receipt, if it has a connection to a case that has occurred within a 3-month period. So that can also loop you in if you're a bit behind on that 3-month component. They also have urgent appeals. So the working group can send an urgent appeal to a state government. It does so when it receives credible allegations that a person has been arrested, detained, abducted, or otherwise deprived of liberty and has been forcibly disappeared or is at risk of being disappeared, or whenever it deems it necessary in view of the situation. And they transmit allegations to the state concerned, and they essentially say, hey, tell us what's happening. We want an update. And when they do this, they can actually work with other special procedure mandates. So that might be the special rapporteur on the prevention of torture. It might be the Special Rapporteur on Migrant Rights. It might be all those other UN bodies that you might have heard. They often come together for these to do that because they're bringing in multiple different violations. Because, like I said, enforced disappearances bring in all these different human rights um, provisions and potentially violations as well. Um, They also do something called general allegations, and that's where they transmit to the government concerned a summary of allegations received from relatives of disappeared persons and the human rights organizations with regard to obstacles encountered in implementation. So essentially, what you're not doing correctly, or here are all the bad things we've heard that are happening. They did issue an allegation to the US in 2024, and the US did answer and engage on that. So those are linked if you want to take a look at those. So now the big question is, what is the role of human rights organizations and legal counsel here? So we can report disappeared individuals who we represent, so our organizations can do that. And we can also assist the relatives of disappeared individuals in submitting cases. And something that's really important here is, when we're dealing with clients and, our community members, often, you know, the person will turn up in some system, maybe, and you haven't had time to do all of this. And so you think, okay, well, I shouldn't report this. And actually, the working group has said, no, please still report that to us, because when we don't get those reports, it encourages that culture of impunity, right? And so they actually still want you to report the information about disappearances, even if by the time you prepare the report or it reaches the working group, you already know the fate and whereabouts of the individual. And that's because, remember, we talked about those general allegations. They can now still include that information that this is happening in the general allegations, even if they're not going to get you the location of the individual, because you already have that. So the big message in this is, as we're helping our clients and we're helping our community members, it's important to take a moment to do this, even if it's something you get to not right away, right? It might be a few days later, it might be a week later, but you should still send that up. If, you know, your an individual remains disappeared and they're not showing up in the ICE detainee tracker and they've been sent to a third country, then we really might need the help of the working group, and it might be even more important to do that urgently. But even if you don't, they really, really, really are encouraging U.S. attorneys to please submit that information in general. And something to notice, they can only, and I know many of us think that, the UN uses all the information and then they churn out these reports, but they're actually only allowed to act and use information that is directly sent to them. They cannot use news reports or even NGO reports independently. So if your organization is writing a report about what's happening, about how people are being disappeared, about these human rights violations, even if you're not asking for help on a specific individual, you can still send that report to them. You can send news reports to them about your clients. You can send any of this information that we are all gathering and seeing and getting firsthand. We should try to be creating a more normal process where that does get relayed up, because that allows all of the UN to actually act on it. Otherwise, they have to act only on what they have, and often that's creating huge gaps, right? So many people on this call I know represent these individuals. So I want to really encourage us to think about ways that we can just shoot off an email when, our organizations release a report or when we have information that we're making sure it reaches them. I have in here a video, but in the interest of time, we will skip it, but I will send the link for everyone. They have a little video of the whole process. Oh, it wants to go anyways. So now we're going to talk about how do we actually report a disappearance to the working group. As we've kind of already discussed, cases of disappearances can be submitted by relatives of disappeared or by organizations, including counsel, who are acting on their behalf. Um, it's important for the working group that whoever submits should be able to maintain communication with the working group and respond to requests for further information, which is why, if it's possible, it's usually better for the organization or an attorney to do it rather than a family member directly. You can communicate with the family member, but that way, it's a bit more streamlined, especially as families are dealing with grief and loss and not worrying about responding to these things. Under an urgent procedure, the case is actually transmitted to the country concerned within 1 to 2 days. I know we all think that the UN operates at a glacial pace. The working group and the committee, for that matter, both of them operate very quickly for urgent cases. So if you submit everything and you include all the right information, they're going to work very quickly to get communications out to the states involved. Also, very different from many other UN bodies that we might have heard of is you don't have to exhaust domestic remedies prior to submitting a case. So you do not have to try endlessly to get information from the US government and to endlessly, to take it to court first, which is often required for other UN bodies. It's not required here. So there's no requirement that you exhaust domestic remedies. If we can't find them and your normal places where they should show up are not there, you can reach out. So the information that you need when submitting a case, these are the absolute requirements. You want the full name of the disappeared individual, the day, month, and year of disappearance, or as much information as you have if you don't know the exact day. The place of disappearance, again, as much information as you have. The state or state-supported forces that you believe are responsible. And it's important to list all the countries you believe are involved. So if you think, for example, for the immigrants who were sent to Seco, then this complaint would talk about both the US and El Salvador. So you're going to list both of those, everything you know. You'll provide information about any search that's been done, so where you've checked, what steps you've taken so far to try to identify someone's location. And then you'll also have to submit the identity of the person submitting the communication. The working group does have an instruction form that's linked on here. It'll also be sent out after. And on that instruction form, it goes over the elements that we just talked about. It does encourage you to use a full name of institutions. Don't use abbreviations like ICE or CBP. And it asks you to describe facts in clear and concise fashion, as much detail as possible. You're looking at only submitting one form per disappeared person. And if there's any information that you want kept confidential, you should flag that for them. Something that the working group has noted as they're trying to do this outreach to US attorneys and advocates is that this does not need to be incredibly complicated. It might be a page, 2 pages of information that you have, and you can give that. You do not need to have all the facts in the universe. You're going to provide what you have, and you can send that up. So I know as we're also busy adding more work, right? But this can be very simple, and I would encourage you to think about just finding a simple format to send it up. And if they need more information, they'll reach back out to you. Obviously, you want to give them as much information as you can, and then ideally they won't have to reach back out to you. They can immediately reach out to the state. And then the way to submit this is there is an online form that's linked here, or you can email them. And that email is also what you can use if you want to send them a report or news information or things that are happening, right, that you're submitting up that necessarily isn't about an individual. So how do they help once they have this information? So they will assess the countries involved based on the case, And the working group will work the case for states that haven't ratified the convention. For us, that would be the United States. And they will reach back out to advise on how to submit to the committee for states that have ratified the convention. You can also go look at the committee website yourself, but I think it's a great starting point to reach out to the working group, and you can tell them, hey, I haven't submitted this to the committee. Sometimes they can just forward the information on. So start with the working group. And then once they've done that, they'll communicate with the country for individual situations or general situations. And it doesn't matter, again, like we discussed, if the violations occurred in the past. So even if it's been a month and you want to make sure to report on something that happened to one of your clients, then you can still do that. Ideally, the country will communicate back to the working group with the information on someone's whereabouts, what's happening. Oftentimes, they also send a whole list of other questions as well that they're trying to get answers to. But if they don't, the working group does try to continue to communicate with that country and remind them. To be honest, right now, the United States probably isn't going to respond. I'm not here to pretend that they will, they probably won't. But again, other countries might. So, what happens next? So, communications from the working group are made public. So, those allegations and any answers, if the country responds, are published. And the working group has actually encouraged U.S. attorneys to uplift these and says they will do interviews, they will do press releases. So this is an opportunity for us to build our campaigns around human rights language, and to take and utilize these experts who want to help us. They've done this so much in other countries, and often the United States has not engaged very heavily. Our civil society hasn't, or at least not as many organizations. And so they're really encouraging us to, yeah, to reach out so that they send these allegations to the United States. And if they don't respond, then we have a press release. Hey, we submitted this for our client. The working group said, hey, what's going on? And, they didn't answer. And this is a way that we can build that momentum. They've done this already. So in April, the working group and a whole bunch of other UN special procedures, different special rapporteurs, and other working groups sent a communication to both the US and El Salvador regarding Seacoat and the Alien Enemies Act. Neither of those countries, neither responded. However, the working group did advise they were in some communication with El Salvador. So again, even though they didn't respond, there appears to have been some sort of communication, which is why I want to encourage everyone that, like, yes, the US might not respond, but another country might. And even beyond these individual communications, the working group can also issue general allegations during its next session to a country. It's not specific to an individual, but addresses systematic issues. So we're all seeing these. So when we bring these up, they can now bring an allegation. And that might be to the US, but it might also be to some of these countries who are entering into the third country agreements, right? When we're pointing this out, we're increasing the likelihood that we're going to get general allegations for these other countries who might be more under greater diplomatic pressure, under perhaps pressure from home to do something different. Also, when we do these, the issues are more broadly taken up by other UN mandates. For example, the UN Special Rapporteur on the Human Rights of Migrants in April issued a report specifically on the phenomenon of migrants going missing or being subjected to enforced disappearance. And they actually talked about these agreements with third countries, and said that these can be considered enforced disappearances. So all of this momentum then is building towards this, but we want to keep encouraging that and giving the UN bodies the information they need to keep writing about this. So the big question for all of us is this even worth the effort? We know the US isn't going to respond. El Salvador is not responding. Why do this? So there is a benefit for the disappeared individual and their family. You might actually be able to identify the location of a missing individual. And unfortunately, given the Supreme Court decision, it looks like we may be entering into a space where we have even more third country renditions, where we have people being disappeared to other countries. And so this may become a tool that we really need to have. It also can create pressure for more human rights compliant treatment, like access to counsel, due process. Um, when they're getting communications, when the government's getting these communications, they may be inclined to be like, oh, yes, we need to allow access to their attorney, right? It can be used to raise awareness in media campaigns and help activate grassroots activism. It can also assist in clients' legal cases because you can use documents produced by these UN bodies that might be specific to your client, talking about the facts of what happened and how that violates due process, how that violates um, all these human rights. Also, the working group members can help provide expert testimony and they can submit declarations. So there's another way to engage them in what's happening to your client specifically. Also, really important is that it can help the families of disappeared individuals feel heard. Because even if the United States is not saying what they're doing as a human rights violation, the UN is feels like, in many ways, an official body saying, yes, what's happening is wrong. And so I think there's a lot of value in that, especially considering kind of the low lift of submitting some of this information. And finally, it does create a formal record of the human rights abuse suffered by a disappeared individual, again, which can be useful in different ways. Other benefits is that it raises awareness of disappearances both in the US and globally. It does create grassroots pressure to stop the violations. And it puts pressure on external countries not to participate in these third country agreements with the US, right? When the special rapporteurs and the working groups are writing about this is going to create more fear for less powerful countries to not engage in these practices, right? The more they see that, they're like, oh, this may not be politically worth it. It might be that their constituents are more aware and disapproving, and it might be that there's an impact in international diplomacy, or they don't want to be subjected to UN or regional body scrutiny in their universal periodic review or in their treaty review. They don't want that now on them. It also encourages external countries to shame the US and countries for participating in the violations, again, likely to have a greater impact for countries other than the US. Finally, we have all of this can contribute to the formation of customary international law. So as independent experts, both within the international system and at country levels, write about the issue, it contributes to norm development, which can become binding. And the future benefits is that it creates pressure for future US administrations at UPR reviews, treaty body reviews. They're going to be forced to answer to this because it's been documented by all of us, which might be more politically precarious for different administrations. So not now, but we're creating that record. It can hopefully lead to change in legislation, new policies. Again, some of that might not even be the US, it might be in other countries. And so that's important to think about that other countries sometimes adopt or treaties can be used directly. You can sue under a treaty in some countries. So what we're doing here, even if it doesn't necessarily create this massive immediate impact at home, it might be creating whole other routes and protections for people, for other immigrants in other countries. Also, documentations of abuses could be used in a future case in front of international or regional courts. We've built this setup of this is happening, this is a system, it's not a one-off. So all of these things I hope are worth the effort, considering that you can do these so quickly. These are things that you can just email off when you're writing up, the report on your clients and on your community members. And now we're at questions, and I have a few minutes for those, so I'll try to get through them. Okay. I will pop into the Q&A. Okay, so one of the questions says that I mentioned that the prohibition on enforced disappearances is customary international law. And does that mean that the exceptionless version, so it can't happen in war or emergencies, etc., is also customary international law? I would argue yes, it is. That is how the UN speaks about it, and that would be correct within the UN sphere. Obviously, I think the US would try to say that that is not true, but I think it would be accurate and grounded within international law to make that claim. Someone asked if we will give other information to read. Yes, I will try to send a bunch of resources, both the working group, the committee, they have very great like user guides. I will send those. We're also developing a one-pager that you'd be able to click through and just get to these forms, and it lists, a definition. So it's like a one page that should help you just be a reference to do that. We are developing that. Um, Someone asked if I know where someone is, but I do not know their fate, and communication with them is being denied, does that qualify as an enforced disappearance? Um, I think if you don't know their fate, what is going to happen to them? Yes. The worst that happens is with the UN, and I think this is kind of special, is let's say you submit it and they determine it's not an enforced disappearance. They can help direct you to the correct UN body. So that might actually be the Working Group on Arbitrary Detention, who also has a ability to take cases and work really urgently, like in less than a week. Um, so if you're like, I'm not sure, I think it's still worth submitting this and getting that information up there, and they can help direct you. If it's not quite the right fit, it should go to this UN body, and they do information share within each other. Um, so yes, I would say I think it does qualify as an enforced disappearance if you don't know their fate, but again, even if not, it's still worth it. Okay, someone said for a grassroots activist who might want to help create a record for people whose story we've heard about, if they want to make contact with a family, given that the UN only wants one report per missing person, is there a way to see if a report has already been filed? This is a question that actually came up when a group of attorneys were meeting with the working group, and they said if you're not sure, you can email them and ask them. So I think that would just email them and ask them or submit it up, and they'll probably tell you if it's already been submitted. Um, but yeah, so they were okay with you just reaching out to them. So someone said, can you reach out to the working committee for a person who is not a present client for informational purpose? I'm assuming you mean like can you report on something that you know, but it's not your client? Um, you do have to have permission from the family. So if you're talking about a specific person, but if you want to submit a like a report generally, yes, you can reach out to them and do that. I hope I answered that question correctly, but if I didn't, please feel free to pop a question back in there. Okay. I think I got through all the questions. If anyone else has any questions, please definitely feel free to throw those in the Q&A. I'll give just another minute for anyone who has any remaining questions. All right, well, in that case, thank you. Oh, I got one more. Someone asked, regarding the fate of an individual, does there have to be an element of risk, danger, persecution, potential torture, or death in that fate? And if yes, is there some requirement that the risk or threat rise to a certain level? No, no, there does not have to be some element of risk, danger, persecution. That being said, the United Nations generally thinks about it as those things come inherently with an enforced disappearance. There is risk and danger and persecution by dint of being disappeared. So they tend to interpret those together, but no, you don't have to prove that they're in danger, simply that they've been deprived of liberty by a government official and that their fate is unknown. You do not need to have some threshold element of risk. Um, Someone asked, so could a person send a list of stories they've heard about without having a personal connection? If they could get a full name, place, and date as a report without being a request for intervention. Yes, right, because if you're sending information, specifically trying to get information on an individual, then you either want to be representing them or you have the permission of the family. But if you're gathering information in a report and you're like, hey, this is the information we know about the individuals, for example, that were, um, supposed to be sent to South Sudan. Um, here's what we know. Yes, you can submit reports and information to them. Um, and for that, you technically don't need to have the full name, place, and date because you're not requesting the intervention. This is now you're just submitting information to them, which is a smidgen different. But if you have that information, that is good. And all right. Okay. Someone asked, let's see this next one. They asked, what can consulates do when the fate of a person is unknown, or can they be involved at all? Yes, consulates are supposed to receive information, and so you can reach out to consulates. Different consulates have different varying levels of responsiveness, so that is a way to try to identify someone who has been disappeared. But if you're not hearing from the consulate, you know, you could do both, right? You can reach out to the consulate and you're waiting for them, and you can also be like, okay, well, we can't find information on the detainee tracker or, information from jails, etc. Um, so you can still reach out to the working group in that case. And then, they do like you to, in that list of things required, say what search efforts you've made. So you might say, I've reached out, to so-and-so consulate. I haven't heard back, confirming it's been X number of days, whatever that is. Uh, all right. I think I have everyone through the Q&As. And again, I will. Oh, is there no? Nope, I think we got them all. I will send out this PowerPoint. We will send out some additional resources. There will be links. And we are working on getting that one pager together so that it's just something easy that everyone can pull up and be like, okay, this is what I got to do to report this information up. And otherwise, thank you so much, everybody. I appreciate you all being here. One final question. Is there any of this that we cannot share publicly? No, all of this is essentially just information that is available. So I think you're good to go, but thank you for checking. The one thing I would say is I do want to make sure let's not over inundate the working group, right? Such that they can't sift through information. It's important that we are getting this information up, but we should be thoughtful about how we do that, right? We're making sure we have a complete report. We're making sure, so while this is an available resource, it's good if we have families, who want to do this, to connect them up to a nonprofit or to an attorney who might be able to do this. Um, and yeah, I just think it's really important that we get this information up, but that we do it thoughtfully, because ultimately there are humans on the other end, and we want to make sure that they can get to those crisis situations right away, right? So my encouragement to utilize this resource and to be conscientious. All right. Well, once again, thank you, everyone. If you have any questions, I realize I did not put my email on the slides, but it is taylor@centerforhumanrights.org. It's also on your registration is my email, so feel free to reach out to me. Thank you so much, everyone, and I was going to say a great rest of your day, but we will keep moving forward together.